Actually, conducting counsel uncle has died.
8
So-
and 9.
8 and 8.
Yes, what do you want?
Matter may be fixed on 6, 11.
6, 12.
11.
I'm for a touch number. Okay. 19 number 8. In item number 9, there is inquiry model.
Huh?
Item number 9, there is a inquiry.
Item number 8. 8. Please again. 6, 11 on prayer of the council for the you are for the respondent. Yes.
No, no, I'm petitioner.
For the petition. The consent of the respondent. And in 9th, same order, you had interim order pass circuit.
Item 16, withdrawal.
May I please, your lordship?
Your
I
name?
have told the case, lordship. I have ruled the case. A.K. Das on behalf of M. Rana, lordship.
The prayer of Sir A.K. Das on behalf of Sir Matter is we not. Yes.
Always.
Item 1.
May I please, your lordship? My lord, this is regular bail application. My lord. Both the petitioners are brothers by relation. They are behind bars for 23 days as of now, my lord. The FIR is at my lord, page 12. May I read the FIR, my lord?
The theft case, we have to see the CD.
My lord, the
One on
allegation-
Huh?
City organized crime is also there, sir. 114 series SS.
my lord, the allegation against the present petitioner is that, my lord, it's page 16, my lord, in the forwarding. Kindly see, my lord, page 16 of the forwarding, my lord. May I read, my lord? Page 16, point number 1, my lord. That during the investigation, tower dump data of the place of occurrence was collected and analyzed. And from the analyze, the mobile numbers used by the accused person, Asiruddin Mulakchan, I am not Asiruddin and Mulakchan, my lord, were found to be present near the place of occurrence at the relevant time of the commission of the offense. Number 2, my lord, the based on the tower dump and CDR analysis, the involvement of the accused person was established and accordingly they were apprehended. Now, my lord, point 3, my lord, this is where the allegation, and point 4, my lord, the allegation against me are that during the interrogation, accused Mulakchan and Asiruddin voluntarily confessed their involvement. I am not both of them, my lord.
Why don't you straight away come to 4?
Yes, my lord. The said accused person further revealed that the stolen articles were sold at Toibur, Ali, and Tafajul. That I am Toibur and Tafajul, my lord.
Hmm.
This is only the allegation, my lord. But nothing has been recovered from my possession, my lord. I have no connection in the
We don't know.
offense, my lord.
City is necessary.
Also, my lord, the stolen property has already been, my lord, recovered from the possession of Ishab Ali, my lord. And I am behind bars, my lord, for 23 days. Only this is the allegation, my lord. And assuming that, my lord, I have any
So
involvement,
you are a receiver of stolen property.
nothing has been recovered from my possession, my lord.
May not be recovered.
Already the stolen.
You may have sold it away to or disposed of it. The city will reveal.
On 14 10. 14 11.
Any earlier date, my lord, is possible, my lord.
From Bogagal.
Obliged.
This is for regular bail application, my lord. The accused was arrested on 22/8/2025. The period of detention was about 70 days as on today, my lord. Kindly see, my lord. FIR page 8. Page 8, my lord. This is a long FIR, my lord. The fact is briefly mentioned in page 11, my lord. Kindly see. Page 11, last paragraph, kindly see, my lord. Page 11, last paragraph. The fact of the prosecution case is that the informal laws and as I had before the officer in charge of Lokhipur PS stating inter alia that acting upon credible imports of large scale recruitment in the Band Alpha organization, it came to light that accused Yasin is actively communicating with the present accused including other co-accused persons through social media and telephonic means with a intent to create unrest in the state of Assam. Is this case? Well, the petition is not the name accused. He has been implicated on the basis of suspicion, my lord.
Not
No-
suspicion on the basis
no-
of revelation during interrogation.
No any banned article or arms has been recovered from his possession, my lord. So, my lord,
Okay, UAP is also there.
Your bill was rejected by the learned special judge after perusing the CD. So we have to see the CD and
Re- it was rejected.
call for the CD.
Form Rotip 13.
Oh, my lord.
May I plead Lordship, regular bail application, my lord, FIR may be seen at page 8. My lord, the petitioner is behind the bar for 51 days. And the mandatory period is 60 days, my lord, in this case.
'74 and '75, one is there, sir.
Basically, my lord, outraging modesty, my lord. The forwarding report, my lord, may be seen at page 13. Fact of the case is that, my lord, the petitioner who works as a goldsmith, my lord, the informant came to his shop and there was an altercation between them. And which resulted this, my lord, FIR, my lord. And now the petitioner is behind the bar for 51 days. My lord, only maximum punishment is 3 years in this case.
I had counsel for the petition. But then application. Against the petitioner is that he inappropriately touched the chest of the victim guard and misbehaved with her.
Highly obliged, my lord. Obliged.
May I plead, lord. Intercepted bail application, lordship. Page 18 is the FIR, lordship. My name not in the FIR. This is substitute matter, lordship. Page 18 particular, lordship.
Considered case.
Lordship. So I want to appear before the, I want to face the trial, lordships, because 4 persons are there. They are appearing. I want to.
Appear,
So, my lord, kindly some protection may be granted, lordship.
but till you appear.
Lordship.
Till you appear.
No, Lordship, kindly, because it is session tribal case, Lordship, this is.
Huh?
Session tribal case, Lordship. So magistrate may not grant bail, Lordship. So my lord, kindly, I want to appear because my name also not name in the affair, Lordship. Page 18 is the
Let us
affair,
see the
Lordship.
charge sheet.
Lordship, yes. Page 20 is the charge sheet, Lordship. And page 25, my name, Lordship. Absconding. Only two ballots stolen by some other person. It is recovered, handed over to the informant, Lordship. And my name appeared in the charge sheet on the statement of the co-accused, Lordship. So I want to face the trial, Lordship. Actually, interrogation may not be required, Lordship. And no purpose will serve also.
But if you have one injured cow at the house of Nobi, in the present petitioner, also rescue from his house.
There is no allegation much against that cow, Lordships. It is my cow, Lordships. And two allegation against two Balok, Lordship. That is recovered, Lordship, handed over to the informant, Lordship. It is recovered from the other person, Lordship. So, my lord, no purpose will serve, Lordship, keeping me behind the bar.
Cow is recovered, but what is the origin of the cow? That is not mentioned. It is a stolen cow or whatever. It can be his cow. Hard land counsel for the pit. Charge sheet has already been submitted with the assistant page showing the petitioner as the content. Perusal of the charge sheet, it appears that the only allegation against the petition is that an injured cow was recovered from his premises. The main allegation as per the charge sheet is that it is regarding theft of cattle of the informant by unknown person. But subsequently the cows were recovered and handed over to the informant. That's reflected in the charge sheet. As regards the cow said to have been recovered from the premises of petitioner, there is no mention in the charge sheet that the state cow was a stolen one. So it's submitted by the counsel for the petition that the state cow belongs to the petitioner. Where I'm having regard to the above, it's provided that the event of marriage upon appearance in blood 4 feet of public magistrate help it is not date of rupees 20,000 with your of like of concerned about with further in connection with the application. But the property that it is pays the price and right influence the frequency. Is the price from us if any. It is standard of
And MBW was issued lot.
NBWA. Yeah, even if it is an NBWA, we have said it will be released on bail on his
Lord
appearance.
Chief.
All right, to also write NBWA issued against the petition. He kept in abeyance.
I'm deeply obliged.
Item 5.
Wait, please, your lordship. Sorry, here my allegation is that the petitioner number 1, my lord, sold the gold boat, my lord, to the informant, my lord, and later on the informant found that the boat is made of fake gold, my lord. And he paid some amount of money to the petitioner number 1, my lord. It is the allegation. The informant belongs, he hails from Rajasthan.
Why would we grant you anticipatory bail for this?
Lordship, may kindly see, my lord, because, my lord, our contention is that we never, my lord, sold that, my lord, this thing, my lord, to him, my lord. And moreover, my lord, the order of the, my lord, my lord, the session judge, my lord, nowhere reflected that there were incriminating materials against the petitioner. Only thing in our anticipatory bail was rejected there, my lord. Well, it reflects that, my lord, IO has collected some, my lord, IO has taken the statements of some of the accused. That's why Mala rejected. But it is nowhere reflected that there is incriminating materials against us, Mala.
Okay, if you look into the lawsuit FIR, it is specific allegations are made against the law.
Passengers need not say that there is material against him. He said that custodial interrogation is necessary.
Well,
That
Mala.
itself presupposes that there is material against them. Okay, CD him.
That is on lawsuit
From corporate.
7.
Oblige, your lord.
Ale,
My lord, this matter may be taken up after some time. The Planet Council is on legs.
clock is ticking. Yes. Okay.
All right.
May I please it? My lord, here in this case, both parties have lost case against each other, my lord. FI is page number 10. This is clearance bail application, my lord. May I read, my lord?
Hmm.
The humble submission is that on dated 2/10/2025, while I was standing near at the top of Abul Hussain in front of the house of the accused persons, then the accused persons with their pre-plan pertaining to earlier enmity trying to drag me at their house. And while I raised hue and cry, then my wife Fatima Khatun and my daughter Farida Begum, Sarjina Faruqi and my son. Aizul Haq and Mofizul Haq came forward to save myself. Then the accused persons armed with lathi dao, etc. Also my family members assaulted and injured them on their person, and also the accused Manjura Khatun snatched away the earrings from my daughter, namely Farzina Faruqi. On the other hand, the accused Momin Ali and Moghrub Ali, with an intent to murder my wife, struck her with an axe, and as a result, the left hand of my wife has broken down and sustained serious injury due to a step made by an axe. Later on, the local public rescued me and my family from the accused persons and admitted at Nagarbera PSC, but the doctors referred my wife at GMC for better treatment, my lord. My lord, close FIR is at page number 16, my lord. One six. The humble submission is that on 2/10/2025 in the morning, there was a simple quarrel between the accused number 1 and my son, namely Moghrub Ali. My brother arrived on the spot and told both of them to go home. Later on, both of them went at home. After some time, at about 9 a.m., the accused number 1, along with other accused persons armed with iron rods, lathi, etc., forcefully entered into my house and assaulted my wife, Nurhamela Khatun. After hearing the hue and cry raised by my wife, then my sister-in-law, namely Samiranessa, come inside the house, and immediately the accused person assaulted her and snatched away her eardol. She sustained grievous injury due to assault.
Your FIR is subsequent one.
My lord, maybe out of the same incident, my lord.
But it
Our
is
case has been registered as, my lord,
the
as
allegation is very specific and previous injury is there.
both parties sustained grievous injury.
CD.
My lord, for the same case, CD has been called on 7/11.
All same date. Please
Kindly
along with
take this matter along with BA number 3536/2025. Seven. Highly appreciate.
Wait, this is your lordship. Lordship, this is a matter, file under 482 lordship for quashing of an FIR lost by the ex-wife of the petitioner number 1 lordship. And the marriage has been dissolved between both the parties in 2024 lordship by a decree of divorce. And this case was filed during the pendency of the divorce petition. And in the meantime, settlement has been arrived at between both the parties. So amicus curiae has been appointed for respondent number 2 lordship. Lordship, FIR is 11, page 11, lost by respondent number 2, ex-wife of petitioner number 1, alleging that some sex were misused by the petitioner number 1 and the 2, that is the father of petitioner number 1 lordship.
what is the stage of the case now?
Lordship, final report has been already submitted, and against that final report, petitioner respondent number 2 has filed one Narazi petition, and that petition is pending, lordship. And during this time, lordship, divorce has been, marriage has been dissolved by
This is premature.
lordship.
For the court decides the Narazi petition. Why have you come here? It
Lordship,
should be decided in your favor as well.
No, lordship, as the marriage has been dissolved and both the parties settled outside the court, lordship, on signing one agreement,
It
And
is
as
regarding
per-
marriage,
Lordship,
regarding a separate offense.
Lordship, as
This,
per,
this offense is not connected to a matrimonial.
Lordship, as per Honorable Supreme Court's judgment, Lordship, the offense, the FIR arising out of matrimonial dispute, and during this time, if matrimonial dispute has been arrived at a settlement, Lordship, then Honorable High Court has the power under 482 to quash the same. And I want to place, Lordship, if Lordship permit me to submit one judgment, Lordship. One is of Honorable Supreme Court and one is of our High Court, Lordship, wherein matrimonial dispute and commercial dispute, the Honorable High Court has the power to quash the proceeding if it was arrived at a settlement, amicable settlement between both the parties, Lordship. In the Supreme Court judgment, Lordship, paragraph 15.1. Page 704.
Or it's not doubted here on the propriety, but the petition is before the magistrate by 6 PM the magistrate. Should have waited.
No, Lordship, already they are separated.
As of now, there is no case against you now.
Final report is pending, pending,
Final
Lordship.
report is
Naraji,
said, it is not a charge sheet, it's the final report.
Naraji petition is pending, Lordship. That
Yes, the Narasi petition is allowed and magistrate issues summons.
then,
there
Lordship,
again-
proceeding is pending before the court,
Yes, it is
Lordship.
pending.
In spite of this, Lordship, kindly peruse 15.1 paragraph of the Honorable Supreme Court.
Which Supreme Court? Which one?
15.1. May I read, Lordship? 2019 5 SCC 688. And the settlement itself, Lordship, both the parties agreed to withdraw all the cases pending before the court, and this case is one of them. The respondent earlier appears, but thereafter did not appear, so amicus curiae has been appointed.
Yes, amicus, what are we supposed to do? Narasi petition is pending, sir.
But here, what has happened, husband and wife met. Who was appointed by authoritative my lord 24/2/2020. In the FI, my lord, some checks were allegedly taken, my lord. So if you come to page 11 of the FIR, my lord, the account number and the check numbers are given, my lord. At page 22, my lord, this is an order of the Learned Civil Court, my lord, allowing the divorce, my lord. Page 22, the check numbers are given that they will not be misused and the divorce was allowed. Only thing here is this, my lord. By order dated 29/7/24, my lord, CT was called for. I have to point that out to lordship because if it was
Then
called
is-
for, my lord,
Whatever the Supreme Court has said, that is when there is a settlement.
yes,
But the fact that they have filed a Narasi petition shows that there is no settlement.
yes. And now without her
How can
presence,
you say matter is settled and so?
without her presence now, my lord, I don't have any instruction.
Lordship, before settlement, Naraji petition has been filed. And in the settlement agreement and the divorce
Why not
decree,
withdraw the Narasi petition?
Lordship,
My lord.
Had the counsel for the response been there, they could have
Then-
accepted.
Yes, my lord.
I guess he does not have instructions from the client.
In the divorce decree, they have settled, but without her presence, my lord,
Lordship, various steps has been taken against her, Lordship.
It is-
Orders,
CT was called for order dated 29/7/24.
Lordship,
But now if the case is sent in FR and then NRC petition is filed.
Let us do one thing, we'll keep this case pending, we'll direct the court to decide on the Naraji petition within a period of 1 month. That's it. Put this up. Then you tell your wife to withdraw the Naraji petition.
Lordship, now they were not in talking terms, Lordship. In 23, judgment has been passed. They were separated. They were married. This is admitted by Lordship. Kindly see the divorce order, Lordship, wherein they both agreed that they will withdraw the cases. And the last page of our petition, Lordship. Kindly see the case. 33 cases were pending, and all are withdrawn. Only this one is pending. Now, she did not appear because
When
she
did you
got.
agree for the divorce?
Yes, Lordship. That's why the problem and various steps has been taken. So, Lordship, the petitioner is suffering because of pendency of this case, Lordship. And as per the judgments, Lordship, when there is settlement is agreed by the amicus curiae,
We have
which is,
serious doubts about the settlement now because of the Naraji petition.
are you doubting about the settlement?
I'm not saying.
No, Lordship, he is not said. He is saying that as per judgment, as per law, if there is settlement between the parties in matrimonial dispute or commercial dispute, then Honorable Court has the power to quash this proceeding, criminal
We are on the
proceeding,
point
Lordship.
of the settlement itself now.
Lordship,
On page 20, the learned civil court order is there, much. But if subsequently Naraji petition is filed, much, then that changes the fact. That is the only problem. I do not know when the Naraji petition was filed, before or after. Not.
in Lordship, personal appearance of the respondent number 2, Lordship. Because as he is not appearing, amicus has been appointed by this court. Now, Lordship, if amicus not admitting the record of the case, then
admitting
the only option,
I'm admitting, my lord. Page 20 is the divorce decree
yes,
passed by the civil court. At page 22, it is clearly stated. But if the Naraji petition is filed, I have no instructions from the client, my lord. I am only here to assist the court, my lord. I am admitting that there is a divorce decree. Page 22, clearly the bank account number and the checks are mentioned, my lord. And then the decree was allowed, my lord. They were divorced, my lord. But now subsequently.
then Lordship,
That
I
were-
pray, Lordship, fix this matter after 1 week so that amicus can place before this court.
How can
What
I
was,
please, my lord?
then why are you saying that
No, I
you
cannot
have no
place-
instruction?
How can I get instructions, my lord?
You are saying,
How can
Respondent
it-
has not appeared, that is why amicus. is-
Yes,
How
Lordship.
can he get in?
yes,
How can I do not have any contact with the.
Like, amicus is not supposed to converse with the party.
Lordship,
It is only
amicus
there
has
to
to
assist the
place,
court.
Lordship, amicus has to assist this court regarding the law point. The law point I am placing before this court and the recent judgment passed by our High Court, Lordship, kindly 23/7/2025, wherein similar matter has been quashed. I have placed, Lordship, criminal petition 731, order dated 23/7/2025. Similar kind of matter, matrimonial dispute settled between both the parties, FIR has been quashed by this honorable court. File order dated 23/7/25.
Have been done in hundreds of cases.
But there is no dispute regarding the law, much. If you settle matrimonial dispute, can be quashed, much. And normally when divorce happens, both parties file cases against each other, that is true, much. But without. Now I do not know, my lord, when Naraji petition was filed, it's a new development, my lord. I do not know, much.
No, not new development, Lordship. It is our petition, Lordship. We have stated specifically. FR has been submitted, Lordship, paragraph 4, page 4 of our petition.
When was it filed?
Lordship,
It was the Naraji petition filed.
date was, we have not, final report is 25/1/2022 during divorce proceeding. Naraji petition is not,
That counsel for the petitioner. Provider, Six. Good question. Of the criminal proceeding. Instituted by the court number 2 against the petitioner. Submitted the final of it submitted by the IO, but in response to the
if the Naraji petition is filed before the divorce decree, my lord, then the record can be called for, my lord. We can see if the date is before or after. If it is before, my lord,
Will direct it because of the narrative. Having regard to the next, before which court is it?
Lordship, CJM Kamrup.
Metro.
Yes, Lordship.
The next CJM Kamrup Metro is directed to dispose of the narrative within the period of 1 month from the date of this order. Till then. Interim order. Or earlier. Then continue. Order. Take a copy of this order. This again after 6 weeks.
Lordship, a date may be fixed, Lordship.
When?
Obliged, Lordship.
Plus,
May it please your lordship. In this case, your lordship, we have challenged the order passed, order dated 21/12/2024, passed by the learned principal judge, family court number 3, giving an interim order of interim maintenance amount of rupees 5,000 liable to be paid by the father, respondent, your lordship. Now, both the parties got married in the year 2018. Admittedly, your lordship, since 17 to 2019, the petitioner, the wife herein, in the trial court, has deserted her husband, your lordship. From that time onwards, they are residing apart. Now, in when the proceeding started, citing various reasons, the application has been filed. We have submitted our written objection, denying all the ground. As per the procedure, we have both the parties, we have filed our affidavit disclosing the assets and liabilities, your lordship. Now, in that documents, we have annexed, being I the respondent father, husband, I have stated all my liabilities, the grounds I have also mentioned here is the ground, where my gross income is gross income is 60,000. Out of that, where we have explained, hardly 10 to 15% of the income remains in my pocket, explaining everything, EMI and all this, my expenditure. In that regard, we have filed an additional affidavit also on 1/4/2025 before the Honorable Court in this case, where we have stated that what remains in my pocket is some 6 to 7,000, because we cannot explain it in proper quantum because it shifts every month. We cannot say, so we have stated in a percentage basis. Now, this
Where is the order?
lordship order is at page 150, annexure 5, your lordship.
What is your profession? What do you do?
Lordship,
What do you do?
I'm an government employee, your lordship, working
Government
at,
employee.
yeah,
The designation of
working as senior assistant, veterinary department, Dr. Vasa.
senior assistant.
Yes. And the wife, petitioner is also working. She is also a government employee. Now, in
This
her,
5,000 is for whom? The child.
yes, your lordship. Now, while deciding the, giving the interim order, this honorable court, the honorable trial court, only stressed upon the, or stated that as I have not denied my income, without perusing the liabilities that I have mentioned in my affidavit disclosing assets and liabilities. Only based on that, 5,000 amount has been given as an order for interim maintenance
No,
to be
what did you
provided.
say, what did you submit about this, your liabilities after 60, your income is 60,000.
In that case, your
So
lordship
what are
may,
your liabilities?
liabilities I have mentioned in my petition. Your lordship may kindly peruse. Column 11, page 92, your lordship, where we have mentioned in, I have also filed an additional affidavit, your lordship may kindly peruse that entire statement I have given in this case, your lordship.
Tell us.
In that, we have explained in page 156 that the remaining cash in my hand, 6,860. At page 56,
Meaning we have
150.
understood work. Where are the,
that I have also explained, your lordship. May kindly see page para 2, para 3, your lordship. Starting from para 3, that is entire has been described in para 3 at page 155 and 156. Now, our grievance, my grievance is that on behalf of the petitioner in this case, while perusing the affidavit disclosing the assets and liabilities, because it is a settled law at this stage given by the Supreme Court also pronounced that working mother is also liable to pay to some extent for the minor child. Custody is also with the mother, your lordship, because he is a
how old is
minor.
the child?
Lordship,
How old is the child?
most probably he is at 5 or 6 years old.
Does he go to school?
Yes.
What is the school fees? School fees is lordship, he will be taking admission on 15th of November, lordship. Is around 35,000.
In the affidavit, the wife petitioner
So what you are saying in substance is that you, despite a salary of 60,000,
no, your
you are
lordship.
unable to provide.
No,
Yes, for your
that is
son,
not my submission.
5,000.
That is not
That
my
is the
sub.
substance of your submission.
No, not your lordship. My substance in submission is that without looking into the liabilities, the court has come into the point, as I have not denied my income, 60,000. So I may
Who
be,
asked you to incur those liabilities?
lordship,
Your son is your first liability.
my net income is my
You
actual
can
income.
take a loan of 10 crores and say that I can't look after my son because I have to pay installment.
That is not why I have a settled judgment, your lordship, of the Honorable Supreme.
Judgment.
I am submitting before your lord. That mother should also provide some part of interim
Who
maintenance.
says he is not providing?
Lordship.
Who says he is not providing?
A statement doesn't disclose anything. She has stated her expenditure is only 26,000. There is nothing explained properly, your lordship. If your lordship kindly peruse
Even if the mother, even if the husband provides 5,000, that will not be enough. With school fees and all the expenses related to it, right? 5,000 will not be enough.
lordship may kindly see
Mother has to spend some.
57, page number 57 and extract 3, your lordship. Whereas we have given the detailed expenditure, she has only, in summarized manner, she has given 26,000. My question is that what percentage of her income she is providing to her son as her interim maintenance? Because we are not denying that we are not, we do not want to pay any interim maintenance, but we want it in a lesser, means your lordship, means what I have, the petitioner in this case agreed that he 3,000 to 4,000, that will be enough. 3,000 maximum he can provide. But 5,000 will be too much. If your lordship may kindly look into this, your lord. The judgment I will also place before your lordship, where it has been settled that wife, mother being an government employee, she is also some part of her income she should showing spent on her means child, your lordship. And custody is also with her with the wife, your lordship.
All the more reason why you should pay.
Lordship may kindly peruse my grounds, your lordship. Ground number C, your lordship. Page number 9. And after calculation of the entire amount that has been placed, it is there the documents that are produced by the wife petitioner, your lordship. After calculating the entire documents, as per ground number K, the entire amount that come up for annual maintenance is around 45,000, your lordship. Now, if a person concerned who has filed the petition, she or he gets the relief in by means of interim maintenance, then what will be the final outcome, your lordship? Final maintenance yet to be decided, your lordship. And in that case, the minor child is getting 60,000. And as per their documents, around 45,000 is enough for the child. It is their submission, their documents, your lordship. We are not placing anything. That is in my ground number K, your lordship. Based on their documents, we are before the honorable court, where it has the lump sum amount that comes out is around 45,000, your lordship. And I have in my family dependents also. Upon me, my old aged mother is there, my unmarried sister is there, and other liabilities are also there. And the Honorable Supreme Court in case of Rajneesh and Neha has given some guidelines based that while deciding any interim or any kind of maintenance, the Honorable Court must look into the liabilities also, your lordship, not the income only, your lordship.
Yes, Lordship. May I please, your Lordship? Lordship, my child was born on 17th February 2019, Lord. Since then, I have been taking care of my child. He has given nothing, your Lordship. Um, and Lordship, the order, as per my learned counsel, as per her the impugn order, it was passed on 21/12/2024, Lordship. And he was ordered to give rupees 5,000 as maintenance for his
He has
child
been
only, Lord.
giving. He has been giving.
No, your Lord, he has not been giving.
He has been giving.
He is not obeying the order of the principal judge, Lord. He is only paying a amount of rupees 3,000 per month, Lord. And only on the month of April we have received the amount of rupees 5,000. Since then, he is not obeying by the order also, Lord. And Lordship, his account of the salary is rupees 60,000 per month, Lord. And as per my learned counsel, she has stated that my total annual expenditure is 45,000, not monthly, annual, Lordship.
It is their statement, their documents, your lordship.
That is not false, Lordship, but that is annual expenditure, Lord. To my child, Lord. My child, 45,000. So he was ordered to give rupees 5,000 per month, which he is not obliged, Lord. He is only giving rupees 3,000 per month. Only on the month of April, we have received an amount of rupees 5,000, Lord. The case is, they have filed this case, the case is pending in family court, Lordship. It is on counseling, Lordship, and as they have filed this case, Lordship, the case is also pending there,
He's
Lordship.
not availed any stay in this case, your lordship. So it is we have not
The
placed
case is not
anything.
stayed, Lordship. But
We have not
date-
placed for any.
only
We have
the
not
dates are
availed.
given, Lordship.
This is the honorable court trial courts.
Even a nominal amount for the child, which is also not given, Lordship. Rupees 5,000 is not given, Lordship. Only 3,000 per month is given from the date of the order, Lord. We have nominal amount, Lordship, which the honor is pleased maybe enhanced, Lordship.
No challenge that order.
Regarding payment, your lordship, I'll have to take instructions. I do not have any knowledge whether it's paying monthly or not. At this stage, I do
Here
not,
we are not concerned with that.
I do not have any
With the
knowledge.
Order. Yes, sir.
But my only submission is that as I have some dependence on my liabilities and other expenses, I have my old aged mother. And regarding lordship, since 2019, the respondent is carrying out the responsibility of the child. In that case, lordship, some other proceedings were also pending. And some proceedings they themselves have quit your lordship. Once divorce has been filed by the wife, she has quit your lordship. Now 1498, these are pending your lordship. Other litigations and other proceedings are also pending your lordship.
Or the relevant. But
Lordship, we have also not denied our income, Lordship, whatever it is, Lordship, it's the duty of the father to give the child. your
It's
Lordship.
duty of both the
But
parties.
Both
your
the
lordship.
parties, Lordship. But since 2019, I have been taking care of my child alone, Lordship.
Lordship,
I have also
admittedly,
liabilities, Lordship.
admittedly,
I have
the
my mother, Lordship. I have also liabilities, Lordship.
lordship, admittedly, the wife have deserted. We never stated forced her to desert. These are other grounds that are subject to trial, your lordship. But I have also not been given the chance to visit my child, your lordship. Since his birth, I have not even visited my child. I have not given the
you
opportunity.
filed
Your
any
lordship.
application for that.
Yeah, that is a different matter. But
That is
as
not a
the
different matter. It
respondent
is your
said,
submission.
res-
If it's a different matter, then why are you submitting?
because it is a part of the entire story, your lordship.
Not a part of the entire story at all. As far as the petition is concerned. If you are not given visitation rights, go to the court, file application.
That is another part.
Why
of
are
it.
you making useless submissions now?
Because 2019, as they have stated, though, it's my reply I have stated.
CAB.
Lordship, I have a judgment. Should I place it before your lordship?
Up to you. Right.
My please, lordship.
Well, in the last occasion, trial for record was called for. It was not received.
My lord,
I think it's what- I think you have to.
my lord,
Let me call for trial for reminder for. The POCTO is there.
Fox is there, my lord. My lord, may I read the FIR, my lord?
Like record for record.
Please, but I have some. Would you submission?
You have called for the LCR, where to lead to by reading the
My
FIR.
lord.
My lord, if your lordship permit, I have two submission, my lord.
Yes.
My lord, first of all, my lord, page number 15, my lord, the affair. The Assamese version, my lord. May I, my lord? Page 15 of my petition.
Yes.
মহাশয় সন্মানপূৰ্বক বিনীত নিবেদন এই যে উক্ত পদকীয়াৰ লগত মোৰ 15 বছৰ 3 মাহ বয়সৰ নাবালিকা ছোৱালী ৰাজেদা বেগমৰ প্ৰেমৰ সম্পৰ্ক আছিল বুলি তাইৰ মুখৰ পৰা শুনিব পাইছিলো তাই উক্ত পদকীয়াৰ লগত বিবাহ হ'ব বুলি তাইৰ মাকক জনাইছিলে কিন্তু তাই নাবালিকা বুলি আমি পৰিয়ালৰ লোকে মানি লোৱা নাছিলো মানে বিয়াখন মানি লোৱা নাছিলো যোৱা 8/5/2003 ইংৰাজী তাৰিখে দিনৰ আনুমানিক 12 মান বজাত তাই মোৰ ঘৰৰ নিচে কাষৰ মানুহ এঘৰৰ মানুহ নথকাৰ সুযোগ লৈ চালি ঘৰৰ ভিতৰত বগা ৰঙৰ চুৰিয়াল কমিটেড সুইচাইড and according to her father committed suicide and according to her father's statement my lord she was pregnant at the time of suicide my lord one minor girl compelled to commit suicide that is very unfortunate, my lord, and her family needs justice, my lord. I also need justice, my lord. That's why, my lord, my only humble submission is that as as the in the page 18, my lord, search sheet, my lord, police showed me as absconder, my lord. Police showed me as absconder. That's why the trial proceeding has been delayed, my lord. From last 2 years, trial proceeding has been delayed. It is for appearances of my appearances, my lord. If your lordship permits me to appear before the trial court, I will appear before the trial court, and the trial proceeding will be speedy one, my lord. That is my only humble submission, my lord. One minor girl has compelled to commit suicide, my lord. Her family needs justice. I also need justice, my lord. That's why I am only trying to appear before the learned trial court, my lord, to cooperate the proceeding, my lord. My only submission is that, my lord.
You are only against the NPW.
Only against the NBW, my lord. Neither against the affair, my lord, nor against the search sheet, my lord. Anything, my lord. Any condition imposed against me by this honorable court, my lord, I am only trying to appear before the learned trial court, my lord. And if this proceeding is has been paid, pending,
My lord, let him
my lord,
appear till his
that's
appearance, my lord. Lordship, the court will consider as per law, my lord. My lord, only,
We consider as per law.
my lord,
as per law, my
my
lord.
lord, till his appearance, lordship may consider, but
Appointment of,
thereafter, when he will appear, my lord,
What is the effect? Yes.
when he will appear, my lord, the court will consider as per law, my lord.
But NBW
Yes.
has been issued, my lord.
306 is there.
306 and section 6.
is there, my lord.
My
Yes,
lord,
sir, lordship was pleased to call for the trial court report.
page 18, my lord, in the para 22, my lord, I have been showed as absconder, my lord. That's why I couldn't appear before the trial.
My
trial
lord,
court.
here is the, and one important thing is whether it, although it was in appearance stage, my lord, if
Appearance
there is
stage.
any PNA or NBW already issued, my lord. If there is a PNA issued, my lord, then it's not for bail, my lord. If PNA is issued, my lord.
My lord, I am only praying for
It
one
has the order
opportunity.
of 16.5, my lord.
Now, next there is 11-11, my lord.
No, 16.5 last order
Last
here.
order, but
Here NBW issued.
Uh,
Thereafter, what has happened, my lord, that is not here.
court has been transferred, my lord. Now the court has been transferred. I have checked in the online status, my lord.
If it is PNA issued, my lord, then he is not.
PNS has not been issued yet, my lord. I'm only praying for one opportunity to appear before the learned trial court, my lord. At any condition, my lord. If I appear before the learned trial court, the trial proceeding will be speedy, my lord.
I am correction number 2. Previously, they have filed accused person filed another similar petition, that is 116/2024. This is also pending. And
Rokibul.
another
Rokibul Mia.
document, this is also pending. 116. 116. And another AB was filed. This is dispute of
Any order?
order dated 19/2025. Accused person is delaying the matter.
It is annexed here.
Yes, offense.
Annexed here.
Not.
And not next year.
If AB has been disposed, is it rejected?
19
Rejected.
2025.
No, rejected.
Rejected.
AB was rejected, my lord. As
If
per
AB was rejected, then this is on similar lines. How can you say that effect would be the same?
my lord.
If we state the NBWA effect would be like allowing the AB now.
I think
Purpose is the same, isn't it?
Lordship, it is PNA may be issued. PNA may be issued. PNA.
Maybe we don't know what that's for.
My lord, I am only for one opportunity, my lord, to
No,
appear.
now different problem has arisen because your earlier AB was rejected.
My lord.
It is nothing other than an AP by another.
Minors.
My lord, kindly look into annexure 2, my lord, search sheet, my lord. I have been shown as absconder, my lord.
Yeah, AP order you.
Police
from
neither
AP order copy.
police search for me, my lord. Neither police called me, my lord. Suddenly one NBW issue.
2024. What the heck? Order 19 to 2020.
Police never searched for me, my lord.
Not necessary to search as he is involved in October. He is repeating it.
If your lordship permit me to appear before the land trial court at any condition, my lord.
So is also there.
Fox is there, my
So is there.
Fox is there, my Fox is, but I am not going to the merit and demerit of the case, my lord. Also, my lord,
Actually, the accused person mentioned their address. It is district.
In your synopsis, I think it's respondent number 7. That's too hard. What does respondent number 5 have to say?
I need some time to find. Feedback.
Well, the accused, okay, we understand that they are, but put the stand of the police with regard to the FIR lodged by the
Respondent number 3 filed his affidavit and stating that the investigation is ongoing.
who is respondent 3?
Superintendent
SP
Police.
Ozai.
Superintendent Police.
Yes, what is the affidavit? What does it say?
It says the investigation is ongoing. Lordship. The paragraph, page number 23.
Right. Hard loaded concept of the people. Government advocate for respondents number 1 to 3. And you 1 to 3 also. 5. Copy of respondent number 6 is not yet complete. There is the affidavit filed on behalf of the respondent number 3. The police died. Very it stated that the investigation is ongoing. The respondent number 3 has been died. Is related to file the status report on the quick by the next week. Have it. Sir. Yes, sir.
Date may
Please give a date. Second.
second.
13.
But I is there, my lord. But basically, the conviction is under 21B, intermediate quantity. And he was sentenced to 5 years, my lord. Lordship will see page number 51. He was convicted under 21B NDPS, my lord, and he was sentenced to 5 years imprisonment. Out of that, my lord, he has already completed 2 years, 2 months. So, my lord, I am not going to submit on merit, my lord. But since it's a case of intermediate quantity, rigors of 37 will also not come. So, till, my lord, the appeal is heard, my lord, let him, my lord, let the sentence be suspended, my lord, on the basis of length of detention, my lord. Since it's an intermediate quantity offense. And he was also granted bail during trial.
How long has it spent till now?
2 years, 2 months.
My lord, here date of judgment was only on, my lord, 19/12/2023. 19/12/2020.
23.
23, my
23.
lord. 1.5 years.
Before that, my lord, he had already undergone around 3 months of in custody, my lord.
So total,
Total will be 2 years, 2 months. 798 days. 2 years, 2 months, no?
you dispute that?
My lord.
Are you disputing that?
No. The earlier whether he was in jail or not, that part is not available as it is in the record, my lord. And as per judgment, my lord, 19/12/2023 judgment was there.
That is in the bail order, my lord. The earlier detention. Bail order of the High Court.
That is there.
Yes, in the record. It is. It will be in the B file, B, no? B file.
But you may also fix it for hearing, my lord, final, but you may also fix for final hearing.
Since we have been allowing this the last few occasions, how can we discriminate? Separate. 40.
Highly obliged.
Map is locked. My lord, by order dated 22/8/2025, this honorable court lordship observed. May it please your lordship. Lordship, I before your lordship is a petition for condonation of delay in preparing the jail appeal, lordship. There is a delay of 154 days, lordship, in preparing the appeal. I am appearing as a legal aid counsel for the petitioner, lordship. The delay, lordship, there is due to such official communication, lordship, delay has been occurred, lordship. And I have explained the delay in paragraph number 5 and 6, lordship. Delay may be condoned, lordship, appeal may be registered.
What about respondent number 2?
Lordship, 2 is a informant, lordship, and they will get the chance in the hearing also. I have made them party in the main appeal and petition for of bail, lordship.
But you may at least issue notice to the respondent, my lord. Here, and
154 days.
delay is also 164 days, my lord.
খণ্ডন করে দিয়েছে। না, খণ্ডন নেই না, তাহলে ঠিক মতো এটা নিয়ে পেয়ে যাবো। যেটা আপনি যেটা রেস্টুরেন্টে কিছু খবর 1
Section 8 POCSO is also.
Whatever section is there, ultimately we have to hear the appeal.
My lord, that is true, my lord, but here, my lord, here, the delay is also there. Some delay is there, my lord. Sometimes they appear and say that we will have to file our objection for formation of.
In cases of long delay, generally objection has been filed, lordship. So these are the delay due to official communication, because the appeal was prepared through the legal aid, district legal service authority and the Guwahati legal service committee, lordship. And application for legal aid has been prepared through the superintendent of jail. And I have mentioned in paragraph number 5 and 6. These are the official communication, and delay of occurred on Thursday's ground only, lordship. And informant has been made party in the appeal, and she will get the chance of hearing in the appeal also, lordship.
Is it coming up for the first time?
Yes, yes, lordship. Because of the delay, lordship, this condonation petition. And after
At least we have to issue one notice.
notice through the office of the public prosecutor, there is a notification.
All right. This is a TLSA matter. Get it to your office. Right. How many days?
154 days.
If I can just. Yes, sir. But, uh, uh, 4 weeks. Give a date. Ito may ito mo yun. Ito. Ito. Seven. Every Yeah. Yeah. Ang tuloy ko yun, ang pumulo. Ama yung nagsiset. Paros. Ang tuloy ko. Mo hal luy ko lang. Bakal yung hindi na bakal may etisal ko sa tun. Dahil